thereafter Colt Gray did point said firearm at said child. He's charged with 2 counts of reckless conduct, being alleged he did unlawfully endanger the bodily safety of Stephen Edwards and Cassandra Ryan by consciously disregarding the substantial and unjustifiable risk that his act of allowing Colt Gray, a minor over whom he had custodial responsibility, access to a firearm and ammunition after receiving sufficient warning that Colt Gray would endanger the bodily safety of another, and thereafter Colt Gray did discharge a firearm multiple times inside a classroom occupied by said victim, said disregard constituting a gross deviation from the standard of care which a reasonable person would exercise in the situation. And he is charged with 3 counts of reckless conduct, being alleged he did unlawfully endanger the bodily safety of Richard Aspinwall, Anna Christina Jeremy, and David Phoenix by consciously disregarding the substantial and unjustifiable risk that his act of allowing Colt Gray, a minor over whom he had custodial responsibility, access to a firearm and ammunition after receiving sufficient warning that Colt Gray would endanger the bodily safety of another, and thereafter Colt Gray did shoot said victims, said disregard constituting a gross deviation from the standard of care which a reasonable person would exercise in the situation. Now, to that indictment, the defendant has pled not guilty and he denies each and every allegation therein. This is what forms the issue that you've been selected, sworn, and impaneled to try. Before we begin the trial, I'm giving you these preliminary instructions on the fundamental principles of criminal law. I will also instruct you on the role of the judge, the jury, and the lawyers, and give you an overview of the trial procedure. So the defendant is charged in the indictment with crimes that are violations of certain laws of the state of Georgia. I want to emphasize to you that the indictment, including all of the counts therein, and the plea of not guilty are the legal procedures by which these criminal charges are brought against the defendant. The charges and plea of not guilty are not evidence of guilt, and you should not consider them as evidence for implication of guilt of any crime whatsoever. This defendant is presumed to be innocent. The defendant enters upon the trial of this case with a presumption of innocence in his favor, and this presumption remains with the defendant unless and until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of a crime or crimes charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crimes charged beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is a doubt of a fair-minded juror, impartial juror, reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given, arising from a consideration of the evidence or a lack of evidence, a conflict in the evidence, or any combination of these. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to prove his innocence. If, after giving consideration to all of the facts and circumstances of this case, your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if no doubt exists in your minds about the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Under our system, it is my duty as a trial judge to determine the law that applies to this case and to instruct you, the jury, on the specific rules of law that you must apply to the facts in arriving at a verdict. I'm giving you some of these instructions now. I will give you more detailed instructions after the evidence has been presented and the lawyers have made their closing arguments. During the trial, I may be called upon to rule on motions or objections to evidence. Nothing I say in making these rulings or at any time during the trial is evidence and should not be considered as an indication that I have any leaning in this case whatsoever. My only interest in this case is to see that it is fairly tried according to the laws and the Constitution of the state of Georgia and the Constitution of the United States. As expected, the lawyers serve as advocates for their clients and are duty-bound to represent their clients to the best of their ability. The lawyers also serve as officers of this court, and as such, they are bound to follow applicable laws, trial procedure, and rules of evidence during the trial. If at any time the lawyers believe that any law, procedure, or rule of evidence is being violated, They may make motions regarding the conduct of the trial or objections to the admission of the evidence. In making these motions or objections, the lawyers are simply seeking to fulfill their duties to their clients and to the court. Sometimes these motions or objections may require the court to consider outside your presence the questions raised, and you will be excused to the jury room. We'll try to minimize the number and length of these interruptions and ask for your patience in that regard. Ladies and gentlemen, trial procedure in a criminal trial is generally as follows. First, the attorneys for both sides have the opportunity to make what's called an opening statement. This opening statement is not evidence. Remember that what the lawyers say is not evidence, but it's a preview or an outline of what they expect the evidence to be. Following the opening statements, the evidence will be presented. Evidence can be in the form of testimony given by witnesses or physical evidence that will be labeled with exhibit numbers for identification. After the presentation of all the evidence, the attorneys have the opportunity to make what's called the closing argument or summation. At that time, the attorneys may suggest which laws are applicable and how they should be considered in light of the evidence, and point out to you certain parts of the evidence that they think are favorable to their position. The goal of a closing argument is to persuade you to decide the case in their favor. Following the closing arguments, I'll charge you more specifically on the law that applies to this case. I will then ask you to retire to the jury room to deliberate and reach a verdict. You, the jury, have a very important role. It is your duty to determine the facts of the case and to apply the law to those facts. I'll instruct you on the laws that apply to this case, but you must determine the facts from the evidence. Evidence, by definition, is the means by which any fact and issue is established or disproved. Evidence consists of two things, testimony and exhibits. Testimony is the testimony that you will hear under oath from those who take the witness stand. Exhibits are those documents, photographs, or other physical items of evidence that are admitted into evidence. Ladies and gentlemen, the object of the trial is to discover the truth. During the trial, the admission of evidence will be governed by certain rules of evidence. Those rules were established with one prominent purpose in mind, and that purpose is the discovery of truth. Consequently, the rules of evidence seek to assure that only the best and highest evidence is admitted for your consideration. During the trial, the attorneys have a right to object to the admission of evidence if they believe its admission would violate a rule of evidence. I will admit or exclude the evidence according to those rules. If I overrule an objection, this means you are allowed to consider the evidence being offered. On the other hand, if I sustain an objection, this means that you may not consider the evidence being offered. You should consider only that testimony and only those exhibits that are admitted. And you should draw no inferences and make no assumptions about the evidence objected to if the objection was sustained. In the event that you hear or see inadmissible evidence before an objection can be made and ruled upon, if the objection is sustained, I would instruct you to disregard it, and you should disregard that evidence entirely in your deliberations and in reaching your verdict. You, the jury, must determine the credibility and believability of the witnesses. It is for you to determine which witness or witnesses you will believe and which witness or witnesses you will not believe if there are some whom you do not believe. In determining the credibility or believability of witnesses, you may consider all of the facts and circumstances of the case, the manner in which the witnesses testify, their interest or lack of interest in the case, their means and opportunity for knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, and the occurrences about which they testify. You may also consider their personal credibility insofar as it may appear to you from the trial of the case. As the fact finder, it is for you alone to determine what testimony you will believe and what testimony you do not believe. Now, it's important that you pay close attention to the evidence as it is presented during the trial. At any time you are unable to hear or see evidence being presented, or if you're suffering from any discomfort that diverts your attention, please feel free to inform me and we'll do whatever is necessary to assure that you're able to hear and see the evidence being presented and to give it your undivided attention. If you are in need of a recess at any time, please raise your hand and let us know. We'll take a break. It's vitally important that you're as comfortable as possible so that you can focus on the evidence as it's being presented. It's important that you view this evidence with an open mind at all times and reach no final conclusions until the trial is over. Do not jump to conclusions before all of the evidence is presented. Also remember that during the course of the trial, it would be improper for you to discuss this case with anyone or to allow anyone to discuss the case with you or in your presence or hearing. This applies even to discussions amongst yourself in the jury room or elsewhere before actual deliberations begin at the end of the trial. Now, the bailiffs have been asked to provide you with pencils and notepads for your use during trial. You may take notes, but you are not required to do so. If you decide to take notes, please remember that note-taking should not divert you from paying full attention to the evidence and evaluating witness credibility. Your observation of the witnesses during their testimony can be vital to your determination of the believability of their testimony. The notes that you take are for your use only and are not to be shared with anyone until you begin deliberations with your fellow jurors. Notes are not evidence, they are only memory aids and should not take precedence over your recollection. It's the duty of each juror to recall the evidence, and while you may consider another juror's notes to refresh your memory, you should rely on your own recollection of the proceedings. Do not be influenced by the notes of other jurors unless their notes help you in determining your own independent recollection. Notes are not entitled to any greater weight than the recollection or impression of each juror as to what the evidence may have been. After the trial is over, the notes will be collected and destroyed. I instruct you, ladies and gentlemen, that you must decide this case for yourself solely on the testimony you hear from the witness stand and the exhibits that are admitted into evidence. So understand you are not to visit any scenes that may be depicted by the evidence. You're not to use the internet or the books for any reason, to do any research for your deliberations. I've implored you during jury selection, I'm going to say it again, pretend like it's 1980 to the best that you can. Stay off the internet, stay off of social media. Do not discuss this case with anyone other than your fellow jurors during deliberations. Now the last thing I want to say is go with the flow. And I say that so that you'll be less frustrated. There will be times during the trial where the attorneys want to talk about something outside of your presence, and sometimes that requires me sending you to the jury room. Sometimes we'll take a break, and I'll say it's a 10-minute break, and you're still sitting in the jury room 20 minutes later wondering what's going on. Something's come up that we need to discuss outside your presence. You may be at your lunch break, and I tell you it's going to be an hour, and it turns into an hour and 20 minutes. We're not wasting time. We're talking about things that we can't do in front of you. You may be on a recess, come into the courtroom, and something comes up, and I've got to send you right back out. I just tell you this to set an expectation. The trials are fluid, and I want you to just, to the best of your ability, go with the flow. Understand that things are going to come up that I have not heard before. I have not heard all the evidence in this case. I've heard very little of it. And sometimes I'm going to need to inquire with the lawyers just so I can speak freely with y'all outside the court. Okay? Now with that, I'm going to turn it over to the attorneys for opening statements, starting with the state. Thank you.
All right, this is the exhibit I'm going to be showing.
Thank you.
Good morning. Before we start, one thing needs to be abundantly clear. This is not a case about holding parents accountable for what their children do. That's not what this case is about. This case is about this defendant and his actions. His actions in allowing a child that he has custody over access to a firearm and ammunition after being warned that that child was going to harm others. This is a case about his actions and the horrific consequences of them. I'm going to take you now to September 4th, 2024. It was a Wednesday morning. It was just after the Labor Day holiday. A 14-year-old boy enters Apalachee High School here in Barrow County. It's a new school for him. In fact, he had been out of school completely the entire previous year. And while the school year was already a month old, this was only his 5th day attending school. As he walked through the crowded hallways, he carried his book bag in front of him. And hidden inside that book bag was a 6-hour M400 AR style rifle. This 14-year-old boy has an evil plan. He goes to his first period class, located here. It's a computer science class. He sits down at the table, and he puts his book bag with the rifle next to him. At some point during the class, he gets up and approaches the teacher, and he asks her, "Y'all had any active shooter drills?" She says, "Yeah, actually, we had one last week. You were absent." He goes back and sits down. Teacher ponders on this a bit. It's not a question to ask.
No.
Since she didn't know this boy very well, he's only been there 5 times. So she emails the school counselor, and she courtesy copies her direction to the vice principal about the question the boy asked. At the end of class, at 9:38, this boy picks up his book bag with the rifle in it, carries it in front of him out of the class, heading to his second period class. That first period teacher stewed on it a little more, and between the class breaks, she decided, I'm going to go up to the office and find the vice principal and talk to her. But at this very moment, that 14-year-old boy is entering his second period class. It's 9:40 a.m. He takes a seat, and he puts that book bag with the rifle in it next to him. 14 minutes later, at 9:54 a.m., that boy gets up, grabs his book bag, and he tells the teacher, I'm going to go to the counseling office, which is located down here. He leaves the class, but he doesn't go down to the counseling office. He goes down what's called J Hall, and he enters the boys' bathroom here. He goes into a stall, locks the stall, and he hides there for the next 26 minutes. Now, 4 minutes before he left second period, at 9:50 a.m., the boy's mother calls the school counselor, who's in this suite here. Now, the boy's mother doesn't live here in Winder. She's down in Fitzgerald, Georgia, which is in South Georgia. It's a 4.5-hour drive from here. But the boy that morning has sent some text messages that will bother her. And he's now not answering his phone when they call or try and get a reply. She's worried about his emotional well-being. Now, the counselor had actually met this boy the week before. He had a panic attack at school, went to her office, and was too upset to go back to class. So the counselor and the mother talk on the phone for 8.5 minutes about this boy's emotional well-being. And at the very end of that call, at the end of the 8.5 minutes, for the first time, that mother mentions to the counselor that this boy has access to firearms. This sends a red flag up to the counselor. She immediately hangs up the phone and she calls the vice principal. This phone call was ended at 9:59 a.m. But remember, the boy had already left the classroom 5 minutes before that phone call ended. 5 minutes before the mother said anything about firearms. And he's hiding in this bathroom where no one knows where he is. 7 minutes after the call ends, at 10:06, the vice principal and the school resource officers arrive at his second period class. Now remember, this boy that the vice principal and the SROs are looking for has only been to that class 5 times. And there's another child in that class who has an almost identical name. And that boy has also left the classroom to actually go to the bathroom. He signed out to go to the bathroom. Second period teacher thinks that's who they're asking for and says he just went to the bathroom. Gives the vice principal that boy's backpack. And the vice principal and the school resource officers head down to the bathroom to find that boy. That boy's just up at the sinks. He comes out with them. They talk to him. They search his book bag. And they realize this isn't the right kid. He doesn't have computer science for first period. They go back to the class. They arrive there at 10:11, back to the second period class. The teacher then tells them, oh, that child has gone to the counseling office, located here, because that's where he said he was going. Vice principal, school resource officers go to the counselor's office. Of course, they haven't seen him. He never made it there. At this point, they decide they're going to go look on the security cameras, see if they can locate this boy. They go down this hall, and it's not on this map. You'll see a more full map later. So around this area is where the vice principal's office is that has access to the security cameras. So they're about right here. At 10:18, the vice principal emails the second period teacher. When did he leave your class? They're trying to locate when exactly he left because remember, this boy's only been there 5 days. They don't really know what he looks like. So they're trying to find him on the video surveillance equipment. So she emails at 10:18, when did he leave your class? 2 minutes later at 10:20, second period teacher responds, he left towards the beginning of class. That's 10:20 a.m. when that email was sent. 1 minute later, at 10:21 a.m., that boy exits the bathroom he'd been hiding in. He's now wearing yellow work gloves. He's carrying that Sig Sauer M400 AR style rifle concealed with a poster board. And he walks back down J Hall towards his second period class. Now, when the vice principal had left that class to go look for him in the counselor's office, she shut the door behind her, and the door automatically locked. This boy is not going to be able to get into his second period class. But next door was another classroom, right here. It was taught by Cassandra Ryan and Stephen Edwards. And inside that class were the following students: Landon Adams, Christian Angulo, Jackson Beaver, Hayden Bowen, Jalene Brady, Michaela Brown, William Carricker, Marquez Coleman, Melanie Delira Castaneda, Natalie Griffith, Taylor Jones, Kendez Lawrence, Martin Moreno Galdamez, Tyler Moon, Ariana Norman, Brittany Rubio, Mason Skirmerhorn, Ronaldo Vega, and Nautica Walker. At 10:20, Mason Skirmerhorn, who's in that room, leaves to go to the bathroom. And the door does not shut behind him. Mason goes down this hallway. He actually passes the shooter in the hallway, and Mason goes into the bathroom. The shooter goes to his second period class. The door's locked. He knocks on the door. A student in that class gets up, goes to the door to open it for him, but sees through the class at the last second him standing there with that rifle. She steps back from the door. At that exact moment, the teachers also reach the door because they've been looking for this boy, remember? And she sees through the glass him standing there outside their door with that Sig Sauer M400. She immediately presses a button on a lanyard that's around her neck that locks down the school. The boy then steps next door to the Ryan Edwards classroom, and he opens fire. He fires discriminately through the classroom. He hits the following victims: Melanie Delira Castaneda is seated here. This is the door he comes into. She's seated here. He strikes her in the left arm with a bullet. Here. Natalie Griffith is seated here. Strikes her in the shoulder, the upper arm, and the forearm.
Right, thanks.
Taylor Jones is seated here.
No, I'm good
Struck
for
to the
now.
leg.
We'll only got one a minute.
Christian Angulo seated here by the door. He shoots him through the wrist into the chest. He would not survive. Jackson Beaver, Ronaldo Vega, and Nautica Walton were also in that room. They were struck by shrapnel from the bullets ricocheting around the room. When he finishes shooting, the shooter then leaves. He runs down J Hall. He's looking for more victims. Christina Iermy is a teacher in this classroom. She hears the commotion. She steps out, looks down the hall. The shooter is about here. He shoots her through the neck before she can get back in the room. She would not survive. Richard Aspinwall is coming out of this room on I Hall. He hears the commotion. Joining him is David Phoenix coming out of this room. The two of them start coming down the hall here. They don't get very far because the shooter has now reached this point. He turns his gun down this hallway and sends a hail of bullets towards them. As they dive towards their room, David Phoenix is shot in the hip and in the foot. Richard Aspinwall is shot in the side and the upper chest. He would not survive. The shooter continues down the hallway. He gets to here, tries to get in this door, it won't open. He turns back and heads this way. At this point, Mason Skirmerhorn is still in that bathroom. He doesn't know what's happening. He comes out of the bathroom, and he turns away from the shooter, doesn't even see him, heading back toward his second period class. The shooter takes aim from behind, shoots at him, but misses, hits the wall above and in front of Mason. This startles Mason, and he turns and runs the other way directly at the shooter. He's shot point blank range. He would not survive. Shooter's here. He then aims his gun down K Hall. And Zane Zinni is locked out of his classroom here. He's in the shooter's sights. Now, before the shooting started, two school resource officers, Donovan Boyd and Brandon King, were in the vestibule area, the atrium, I think they call it, in this area, right outside the vice principal's office. They're waiting for the vice principal to find this boy and go get him. They're waiting out there in the atrium, and they hear the gunshots coming from this side. And those two deputies ran towards the gunshots. They come down this hallway here, and they turn the corner, and they see the shooter here with his rifle aimed towards Zane Zinni. And they yell for him to drop the gun and get on the ground. And he complies before he gets a shot off at Zane Zinni. The officers rush down here, they secure him, and they secure that 6 Sauer M400 AR style rifle. And out of his pockets, they find 3 more magazines loaded. Now remember when the shooter had tried to enter his second period class and the teacher pushed that button? Well, that sent an alarm. It immediately notified law enforcement all over the county. Within minutes, an enormous police and medical response descended upon that school. It was a dramatic and intense scene as the school was cleared and the wounded evacuated. But to make matters worse, they were getting additional threats, fake threats, about other shooters at all the other schools in the county. Law enforcement now had to be diverted to these other schools to clear them to make sure people were safe. Barrow County deputies Anthony Townsend and Brandon Bazinet were sent to clear Winder-Barrow High School here in Winder. Once they cleared it, then they went next door to Russell Middle School. They cleared it. And just as they were finishing that up, they got a call from their superiors. I was trying to say superior and supervisor at the same time. Their superiors to go to a residence in Barrow County and secure it. They were just given an address. They don't know why they're going there. They were just told, go to this residence and secure it until other officers can arrive. Where they're going is the shooter's house. And when they get there, Colin Gray meets them in the garage. And without any prompting, because remember, they don't know why they're there. They don't know who this guy is. Without any prompting, he blurts out, "I knew it. My little girl just texted me. She's in middle school. She said we're in lockdown." I'm like, God Almighty, please tell me your brother didn't do something. Agents with the Georgia Bureau of Investigations arrived shortly thereafter, and they begin a search of the house. And inside that house, in that 14-year-old boy's bedroom, on the wall, they find this shrine, for a better word. Those pictures are all of the same person, Nicholas Cruz. Nicholas Cruz was the person that in 2018 went into Marjorie Stoneman Douglas High School in Parkland, Florida, with an AR-style rifle. And there he killed 17 students and faculty and wounded another 17 more. Investigators look at this and they begin to wonder, who is this kid? His name is Colt Gray. He's the oldest son of Colin Gray. His mother is Marcy Gray. He has a younger sister named Jenny, who was 13 years old at the time of this incident. She was actually going to Heyman Morris Middle School, which is directly next door to Apalachee High School. He has a little brother, Coley, who was 8 years old, was going to elementary school. Now, Colt Gray, raised here in Barrow County, he went to Statham Elementary School up until fourth grade, up till the beginning of fourth grade. And in the beginning of fourth grade, he was withdrawn from Statham Elementary School because the family had moved. They moved to Gainesville. And he goes to White Sulphur Elementary School, but only for a few months. Because again, the family moved again. Now they moved to Cumming. And he goes to Chattahoochee Elementary School. But again, only for a few months. In March of 2020, they moved to Fitzgerald in Ben Hill County, Georgia. It's South Georgia, kind of Polhamus live. And Deborah Polhamus's mother, Marcy's grandmother, Colt's great-grandmother, had passed away and left the house. So there's an available house for them to live in. So they moved down to Fitzgerald on March 4th of 2020. But if you remember that day, that's the week before COVID shut everything down. That was the end of Colt's fourth grade year. Fifth grade. Now this is going to be the fall of 2020 into the spring of 2021. That's fifth grade year. Colt goes to Ben Hill Elementary School. But remember, this is when COVID is raging, and it's mostly virtual. He's mostly at home using the school computers. The next year, sixth grade, fall of 2021, he starts a new school, Ben Hill Middle School, because he's in sixth grade now. And early in that year, 11-year-old Colt, at home, using the school computer, searches the word abuse. A few hours later, he searches the phrase, "How to kill your dad." That was on September 19th, 2021, 3 years before he took that rifle into Apalachee High School. School resource officers are sent to the house to check on him. Everything's fine. It was just a mistake, misunderstanding. But a defects case is opened on the family. But the family leave Fitzgerald and move to Jackson County 6 weeks later in November of 2021. So in November, they come up here to Jackson County, Georgia. But they don't enroll the kids in school until February of 2022. Colt finishes out his 6th grade year at West Jackson Middle School. 7th grade, fall of 2020, 1 year after he searched How to Kill Your Dad, and 2 years before Apalachee, 12-year-old Colt starts Jefferson Middle School. It's his 7th school in 4 years. That Halloween, halfway through the semester, Marcy, his mother, gets drunk, passes out in the car in the driveway of the house. Jenny and little Coley are trick-or-treating, and they get separated. Coley gets lost. Authorities are called. Another defects case is opened on the family. Marcy and the 2 siblings, little Coley and Jenny, they move back down to Fitzgerald in November of 2022. But Colt stays up in Jackson County with the defendant. Defects caseworker Tamika Mitchum is monitoring Marcy and the 2 siblings down in Fitzgerald